My name is Jeff Sifers, the Oklahoma Traffic Safety Resource Prosecutor. In this segment, we're going to talk about DUI defenses generally. In the reviews of your cases, be sure to look at the cases as an officer does in his creation. When an officer attends field sobriety testing school or they go to the academy, they're going to learn that a DUI is a process of information. They're going to learn that there are 3 phases in a DUI arrest: vehicle in motion, personal contact, and pre-arrest screening. The vehicle in motion's easy. That's the initial observation, what the officer saw. Was it speeding? Was it drifting? Was it swerving over certain lane lines? Whatever put the officer in touch with the defendant and put the vehicle on the side of the road is your vehicle in motion. There's the next step, which is personal contact. That's the time that the officer is going to have the opportunity to speak with the defendant. What did he see there? What did he hear? What did he smell? Did he hear slurred speech? Did he smell an odor of alcoholic beverage? Did he see bloodshot, watery eyes or disheveled clothing? It's at that point that you're going to start determining the impairment of the individual. Then comes a pre-arrest screening, and it's in that pre-arrest screening that field sobriety tests will be done. There may be also a portable breath tester that's done, a PBT. After the determination of impairment and the arrest, there may be a chemical test that's offered. And then when did the officer take the individual to jail? Each of these time frames is a highlighter moment in your report review for cross-examination questions. Because in every one of these environments, in every one of these circumstances, a defense attorney can challenge the opinion of the officer, challenge the validity of the arrest, challenge the basis of the chemical testing. So when you're reviewing your reports, prepare yourself for cross-examination using these highlighter moments. And in this, we want to talk about really the understanding of the defense position, perspective, and focus. We want to kind of hope that we can determine the validity of certain defense challenges and how they apply to the individual case. And we want to know whether or not the challenge applies to the admission or weight of the evidence. And hopefully at the end of the day, we'd like to make sure that we have a plan to proactively prepare for testimonial questions to counter those defenses at the outset of the case as opposed to after cross-examination. Now, defenses in DUI cases are largely interpreted now by the defense attorneys as no longer automatic convictions. If you look at some of the defense websites, you'll find that there are claims that because of the scientific challenges to evidence and standards that have to be followed by law enforcement to make a blood or a breath, alcohol, and or DUI drugs case, the accuracy and the arrest determination may have a higher standard on those law enforcement individuals than they have been in years past. And a defense attorney might claim that depending upon the facts of your case, you may have a defense even if you're technically guilty. We want to defend against that, especially going forward, because in the defenses that you'll see, the DUI defense bar is going to employ what I call the DUI defense trinity. They're going to try to suppress the evidence. They're going to try to substitute alternate explanations for the evidence that you're offering, and or they're going to try to ignore that piece of evidence that hurts them. They're going to suppress it because they want to keep it out if they can. If the defense bar can prevent a jury from hearing the evidence or a judge from considering the evidence, then they don't have to worry about it any longer. If they can't suppress it, they're going to use cross-examination to search for alternate explanations for the evidence. If they can't use the cross-examination, then they're going to offer certain substitutions to the officer of, could it have been? Would it have been possible for? Remember that cross-examination is going to be used for subjective evidence like field sobriety tests or drug recognition expert protocol. Blood and breath testing is going to be objective evidence that's going to result in a battle of experts. But when a defense attorney tries to substitute evidence, remember that it's the officer's determination and the officer's opinion that's going to win the day. Always ask your officer whether or not his opinion has changed following cross-examination. If there is a piece of evidence that a defense attorney sees as a harm to his case, it only needs to be heard once. If it's a piece of evidence that your officer testifies to and creates a great case for you, and you don't hear the defense attorney mention it again, it's your responsibility to bring it up again. And then again, in addition to ignoring a piece of evidence, you might find that the defense attorney will focus on the good stuff that the defendant did right. For example, in standardized field sobriety testing, there is a protocol that the individual has to follow to make sure that the officer is doing the field sobriety test correctly. There are certain standardized scoring clues that the officer uses to determine whether or not those clues can be used against the DUI defendant. Those scoring clues may be present in all cases. There only may be 2 clues of 4 in a one-leg stand, or 3 clues of a walk-in turn. And the defense attorney is going to try to focus on the 5 clues in a walk-in turn that the individual did right, or the 2 clues in the one-leg stand that the individual did right. Remember that it's the officer's interpretation of those clues that are going to be what is used to determine the impairment as a screening tool. So if you employ your evaluation of your case, trying to figure out what a defense attorney is going to try to suppress, or trying to anticipate what substitutions of a piece of evidence might come, or focus on the pieces of evidence that you know that the defendant is going to try to ignore, then I think that you're going to be well prepared for your prosecutions. Remember that in every case, once you've put on your evidence, the defense is going to have the opportunity to cross-examine your officer. In those cases, you're going to find that the defense attorney is going to try to get the jury to question what was done and how the officer did it, the validity of tests in field or chemical tests. They're going to try to gain any concessions, or they're going to challenge the competency of your officers. But overall, they're going to try to attempt to create reasonable doubt. Remember that every piece of evidence that's going to be challenged is going to be challenged on an island as an individual piece of evidence. Also remember that every piece of evidence in a DUI case, if challenged on an island, will never prove somebody guilty in and of itself. So also remember and make sure to stress that it's the totality of the circumstances available to your officer when he made the determination of impairment in the DUI defendant. You can weather a great deal of storms through cross-examination. When you have the opportunity for redirect following the storm that is cross-examination, remember that it's the officer's opinion that matters, not what was gained during cross-examination, not the certain things on the individual basis that you have to offer your own explanation for, but it's the officer's opinion that matters. So ask him, officer, did the cross-examination by the defense attorney change your opinion? And it's likely that his answer is going to be no. And that's what you stress to the jury. It's my sincere hope that employing some of these tools, you will have a more effective prosecution in your cases. And your traffic safety resource prosecutor in your state is happy to help. Feel free to contact them or the National Traffic Law Center for some more guidance and specific defenses. Thank you.